All right, good afternoon, everyone. We're at the top of the hour here, so thank you all so much for joining us. My name is Kedar Sankararaman. I'm a policy counsel at the Association for Competitive Technology, ACT. We're a global trade association for small and medium tech companies. And part of our important policy work for our members who are small businesses in the technology sector is to look at policy areas and policy proposals that affect them, even though they may not be target of the policy proposals uh, on the surface of it, on the face of it. And it is in that context here that today we'll be discussing the Compete Act, AB 1776 in California, which would amend the California's antitrust laws, the Cartwright Act, to mandate to create additional cause of action for single firm conduct. And we have experts here on the panel who can speak to it in more detail, but just on the surface, currently, single firm conduct is governed by federal law, the Sherman Act, Section 2, which has a rich history of case law and precedent based on which industry can judge their actions. And what the California proposal would do is create a divergent standard at the California level, which would have impact nationwide. The bill passed Assembly a couple of weeks back, and it's moved towards the Senate. It's set to be heard before Senate Judiciary Committee in California on June 30th. So to discuss this and its impact on innovation and small businesses in particular, we have an excellent panel of experts who've been in this field for a long time. And in alphabetical order, we have Ben Golenbuck, who's Executive Vice President, Chief of Staff for Policy at the California Chamber of Commerce. Ben represents the broader California business community and will help us ground this conversation in the practical day-to-day economic impacts these proposals will have on the companies operating in the state. Thank you, Ben, for joining us. Next, we have Bilal Sayed, who is counsel at Cadwalader, Wickersham and Taft, and also senior competition counsel at Tech Freedom. Bilal brings invaluable practical experience from his time at the Federal Trade Commission, making him uniquely positioned to explain how California's proposed merger rules and single firm liability standards diverge from established federal precedent. Thank you, Bilal, for joining.
Thank you.
Next, we have Joseph Coniglio, who's Senior Counsel and Director of the Schumpeter Project on Competition Policy at the Information Technology and Innovation Foundation, ITIF. Joe brings deep expertise in civil antitrust enforcement and has been a leading voice on why America's existing antitrust framework is better suited for the fast-moving digital sector than European-style ex-ante regulation. Thank you, Joe, for joining.
Thanks for having me.
And last but not least, we have Satya Marar, who is a research fellow at the Mercatus Center at George Mason University and an AI and competition fellow at the Innovators Network. Satya has written extensively on the unintended consequences of ex-ante digital regulation, and he brings critical insight into how rules like the EU's DMA, the Digital Markets Act, are already impacting competition and AI development globally. Thank you, Satya, for joining.
Good to be here.
So thank you all for joining. Bilal, if I may come to you, could you set the stage on what AB 1776 is? What is the impetus for the bill? And what does the bill actually do in the context of federal law that exists in the US as well?
Okay, thank you. I will try to do my best here. So California apparently seeks to adopt a single firm conduct law that differs substantially from federal antitrust law. First, it will create a category of single firm restraint of trade activity, which in our reading of the bill creates a almost universal duty to deal for any firm with a market share in the range of, let's say, 30%. This is a substantial difference from federal antitrust law, where restraint of trade prohibitions require an agreement between two firms and do not directly address the question of whether a firm or does not require a single firm to deal with firms or customers or third parties that it does not wish to deal with. There's a narrow exception to that, but we'll come to that. So in the first instance, it creates this, what we think is a single firm duty to deal requirement for any firm with a market share of 30% or so and above. Its second component is to adopt and then adapt the language of Section 2 of the Sherman Act. Section 2 of the Sherman Act prohibits monopolization, attempted monopolization, and conspiracy to monopolize. The bill's language would adopt that language, add a clause about maintaining monopoly, which is fine. That's in the federal case law, so we don't think it adds much in the way of problematic issues. The bill would also include a monopsony claim, make clear that the monopolization prohibition extends to monopsony, right? So the use of monopoly power on the buy side. That also is, in federal law through the case law. So it's not it's not a very troubling development. But it is an extension of the statutory language of federal antitrust law, federal anti-monopoly law. Where the bill creates significant issues with respect to Section 2 of the Sherman Act, or application of Section 2 of the Sherman Act at the state level, is that it prohibits the California courts from adopting the legal reasoning and legal principles articulated in federal antitrust law over over 100 or 25, 35 years of development. In particular, it would prevent or prohibit state courts from adopting the framework for adjudicating predatory pricing claims that we think would have the effect of preventing or limiting discounting practices by large firms, and maybe by most of any firm with some semblance of significant market share. It also would establish a duty to deal through rejection of federal case law that limits the requirement that a single firm deal with other firms. Those are, I think, the main issues and limitations. There are others who are smaller, more maybe technical details that would basically have the similar effect of disregarding federal case law and thus differentiating California state law from federal law in a manner that we think would encourage inefficient conduct and would prohibit to some degree discounting and pricing strategies based on lower prices. And that would also create disincentives for firms to adopt practices that we think are efficient and pro-consumer, but that may reflect efficiency benefits that its competitors cannot meet, thus setting larger firms up for lawsuits that would limit the use of efficient distribution and pricing practices.
Thank you, Bilal, for that. And the context, also one point I want to interject from a small business perspective is the ecosystem that exists in a symbiotic relationship between smaller and larger firms is how small businesses reach the consumers. In a market where trust is critical, they use established channels to enable trust, to establish trust with the consumers. Joe, if I may come to you to get into the weeds of the bill a little bit, and weeds of antitrust law a little bit, which I know you like to go into. The language of the bill contains terms like it applies to one or more persons, and it unreasonably restrains trade. For a layperson, this doesn't necessarily seem like pretty standard shifting, But I know that from federal antitrust law, these are different divisions, these are different parts of federal antitrust laws. Can you go into why the significance of the wording of including one or more persons and also looking at unreasonable restraint of trade conduct by one or more persons? How does it diverge from federal standard that exists?
Sure. Well, thanks, Kedhar. And you're absolutely right. These are obviously very important terms under the federal antitrust laws, the Sherman Act. Under the Sherman Act, we really have two broad categories of offenses. So the first, under Section 1 of the Sherman Act, is for concerted conduct, actions among multiple firms, agreements, which are illegal if there is an unreasonable restraint of trade. So that's where you get that restraint of trade language. So think about cartel agreements, for example, or vertical exclusive dealing agreements that are anti-competitive among firms. That's concerted action, Section 1. The second bucket under the Sherman Act is Section 2, which involves offenses not by a group of firms, but a single firms, monopolization, attempted monopolization. We only condemn those practices if there's monopoly power or some sense of dominance, right? This is where we deal with things like predatory pricing and refusals to deal, which again are going to be legal under the Sherman Act for firms unless they have monopoly power or some kind of dominance. Now, if you read the Compete Act, it really doesn't look like it's actually following this approach that we use under the Sherman Act. So what it says is that it's illegal for one or more persons to either monopolize or act in restraint of trade. Now, if you read it as saying that, okay, the first part, one person applies to monopolize, and then the more persons applies to restraint of trade, well, then actually it's broadly consistent with the Sherman Act, right? But if you read what it literally says and what I think it means, you can have single firm offenses that are either monopoly or restraint of trade offenses, right? And you can have even multi-firm monopoly offenses, right? Not just restraint of trade. And then you really have a substantial deviation from the legal framework under the Sherman Act, right? So take the first possibility of the single firm restraint of trade offense that Bilal started to discuss. The problem here is that you'll be condemning behavior by a single firm, even if it has no monopoly power or dominance, right? The statute only requires some semblance of market power, which may not be that common, right? Or may that be uncommon in many cases. And what's going to happen is that's going to condemn practices that really aren't anti-competitive, where you don't have any concerns about market failure or dominance or monopoly, right? Chilling false positives or conduct that's competitively neutral, let's say. So what I think you'll get from this maybe is something approximating Section 5 of the FTC Act's ban on unfair methods of competition, where we go after unilateral conduct where there is no showing of monopoly power or dominance. And there's been a lot of problems with enforcement of Section 5 over the years. So on the other hand, you also now have this idea that maybe, more than one person can be engaged in monopolization, right? That's also a possibility under the statute. And that may seem weird, but actually it isn't unprecedented when you look at Europe, because Europe has this idea of collective dominance, right? You can have dominant monopolization behavior by a group of firms. And you don't even have that in the United States, certainly not under the Sherman Act. And what this can be really used to do is go after tacit collusion or oligopoly type of behavior, which again you don't really get that under the Sherman Act, but you can use Section 5 of the FTC to go after that a little bit when you think about facilitating practices. So again, I would say overall, the way this reads, it looks like it's really creating new categories of conduct for the California law that don't exist under the Sherman Act. And maybe in some ways we're giving it sort of an FTC type of power, which is really something we want to keep to administrative agencies, and it really opens up a whole host of issues given the private enforcement and other things associated with this bill. So I'll just stop there from now, but hopefully that's helpful context.
Yes, it is. Thank you, Joe. And one thing that comes out clearly is, from a business standpoint, uncertainty in how the language can be interpreted and what that means for potential liability from business conduct. Ben, if I may come to you, from the perspective of the California business community, what has been the reaction from the state business community on the proposal and on the discussions that have been happening on the proposal at the assembly side? What's the reaction that you're getting from business members there?
Thanks so much for the question, and again for the invitation. Sorry, I'm actually heading over to meet with a senator on the bill in a little bit, so I'm off camera just for now. I'll be back on in a little bit. I will say, the reaction from the business community has been unified, which is not always, candidly, on legislation, but it is unified, big and small, regionally, by industry, by so I mean everybody is unilaterally and unified in its opposition to it. I've never seen a bill that's gotten more opposition more quickly. And despite sort of taking two sets of amendments now, literally nobody's removed their opposition to the bill, which is pretty telling because normally you take amendments to a bill because you're trying to remove opposition or garner support, and they've managed to do neither of those things. So, yeah, I mean, the coalition is as big and broad as I've ever seen. We've got, hundreds of people sort of activated and working on the bill and doing outreach, both here in Sacramento and in folks' districts. Just for a little bit of color. So, the bill sort of squeaked out of the state assembly. Again, it's being authored by the majority leader of the assembly. So somebody with sort of close relationships with certainly the 60 Democrats in the assembly. Again, they have a three-quarters supermajority in the assembly. It only got 44 votes in the assembly to pass. So 16 Democrats didn't support it, and the entire Republican caucus didn't support it. So it only needed 41 votes to pass. It now goes over to the State Senate Judiciary Committee, where it'll be heard on June 30th for a hearing there. We're working it very hard. I will say I heard from a number of assembly members who basically said, versions of, I really don't like this bill, but the assembly majority leader basically called in all of her chits and asked me to do her a favor to at least pass the bill over to the Senate and let her keep working on it. So we'll see sort of what that means. But it's I think I saw a stat that over the last 15 years, less than 1% of bills were actually stopped in their houses of origin, which means assembly bills got stopped in the assembly or the Senate bills got stopped in the state Senate. So it is extremely, extremely rare when that happens. I was pleased, honestly, we kept the vote count down in our conversations with senators. They're certainly aware, there's serious concerns and opposition to this bill. So I've been really proud and happy to see, again, basically every industry I can think of out in force and in opposition to this bill.
Thank you, Ben. And I'll come back to you on the nuances of how procedurally it goes back from Assembly to the Senate and in terms of amendments. But before that, Satya, if I bring you on, Joe briefly alluded to a European style approach when he was answering. I know you've done extensive research on DMA style, Digital Markets Act style ex ante regulation. If you had to say concisely, like, what are the lessons from this type of regulatory approach in Europe? And what are the lessons that are to be drawn from there as California policymakers consider similar digital markets laws here in the US?
Yeah, sure. Thanks. So what the Digital Markets Act in Europe tries to do is it doesn't even really brand itself as competition regulation. It brands itself as digital platform regulation. So singling out specific kinds of firms on the basis that, they have too much power over our lives, or they, control the ability of smaller businesses to enter the market and so on. And it classifies these firms, almost all of which are large American tech platforms, as being so-called gatekeepers, not based on necessarily their market power or ability to abuse it, but based on other measures like the raw turnover globally and things of that nature. So you already wind up with some absurd situations. So, for example, the DMA imposes these really heavy, painful, costly obligations on, let's say, Amazon, even though Amazon is by far not a monopolist in terms of many of the products it sells. So in many European countries, Amazon is not the number one e-commerce platform. Local commerce platforms are ahead. And in the case of many kinds of products like fashion, for example, in many European countries, fashion e-commerce, there are other websites which rank ahead of Amazon. And Amazon has to comply with a lot of obligations, which these platforms don't have to comply with. So in a sense, it's creating a barrier to competition rather than punishing firms based on abuse of monopoly or market power. And in a sense, the Compete Act is broadly similar. It doesn't say you can't consider a firm's market power, but it says that's kind of optional. And it doesn't really replace market power as a barometer for whether a firm is able to do something anti-competitive. It leaves that question blank and open. And it says that federal precedents in the Sherman Act are merely persuasive. But then it also says and clarifies that the Cartwright Act is meant to go beyond the Sherman Act. Um, and this is really a huge problem because it leaves the doors open for judges to interpret cases in the way they want to, and in a way that is really angling towards being more restrictive of various business practices that can have pro or anti-competitive implications. Predatory pricing was mentioned, for example. What looks like predatory pricing in many situations is simply aggressively competing on price, which is why there's a Sherman Act precedent saying you have to show that the defendant had a realistic chance of recouping their losses by raising their prices later. That's what makes it predatory. Now, by getting rid of all those precedents, you're rewriting the slate and making it highly difficult and questionable as to whether a small business or any business can go out there and aggressively compete on price. So you're creating an incentive really for businesses to behave cautiously to avoid legal liability in a way that could hurt and harm consumers.
Thank you, Satya, for that. I'll come back to your points, some of the points you raised in that in more detail shortly. Ben, if I may come back to you, you alluded to where the bill is procedurally in California, passing the Assembly into the Senate. And can you explain the process of getting it across the line in the Assembly? Like, were there any commitments made to amend it? Can you explain that for the audience as well?
Yep. Thank you. That's a great question. Yeah. So again, at the legislative deadline, which was the end of May, the majority leader was well short of the vote she needed to get the bill passed out of the Assembly. Again, she sort of talked about some of the tactics she used to try to get it out. One of the things she did was she committed to amending the bill once it gets heard in the state Senate. Again, it's going to get heard in the Senate on June 30th. So any amendments wouldn't go public really until that hearing in the Senate Judiciary Committee. I know the ACT team has a set of the sort of the draft amendments that are going to go into the bill, and certainly please feel free to share those with anybody here and or any other of your members. Those are free to disseminate. So, long story short, she agreed to strike Section 3 of the bill, which certainly was one of the many problematic pieces of it. We thought initially that was going to be an improvement to the bill. Unfortunately, her sponsors and the attorneys at the Economic Security Project sort of snuck a provision in to Section 1 of the bill, and that's how the bill will read sort of on June 30th for its hearing, which still basically outlined that courts should not basically use federal law to sort of assess the viability of a case here in California that gets filed, basically to ignore all federal law. And that's obviously been one of our main issues with the proposal all along is it's essentially just basically dismissing over 130 years of antitrust law. The state Supreme Court here has ruled, multiple times, dozens of times, basically saying that federal law sort of underpins everything getting done on the state side on antitrust law as well. And so for this sort of blanket dismissal of federal law is incredibly problematic, and again leads back to totally untethering state antitrust law from federal law, which is certainly one of the main goals here of the proponents. So again, the bill will get heard in June 30th on June 30th in the State Senate Judiciary Committee. It sort of gets a full public hearing there, and then the senators will vote on it. I will flag for anybody planning on tuning in. That will likely be at least a 12 to 14 hour hearing. that day. So I don't know, and I will not know when the bill will get taken up, sort of in that time frame. But that's it will be a long day, and it'll probably be a long hearing at that point. So, anyways, that's where it stands. Again, the amendments that I discussed that the author committed to taking will not sort of show up in print until that June 30th time. But I know, the ACT team has a copy of what those amendments are and certainly can share those out with folks.
Thank you, Ben. And yes, for anyone interested, we can share it out. And we will join you in solidarity for that day, keeping track of the proceedings the whole day. So, jumping on top of that, coming to you, Joe, like Ben mentioned, how the bill would essentially set aside, like decades of case law interpreting federal antitrust law, and how the amendments may not necessarily help with not setting it aside. Bringing it to like, why is case law important in antitrust policy here in the US? Can you like explain the importance of the history of interpretation of federal law in antitrust policy here in the US?
Yeah, sure. I mean, I can certainly see why the business community, for example, would be very concerned about the prior Section 3, and also very concerned about what may still remain, in the sense that there's still this general idea that we're going to go, and we want courts in California to go well beyond the federal precedent that had been developed, over a century, so that we get in California much more lenient standards for plaintiffs to prevail. So, I mean, think about some of the examples here. I think that's the best way to think about it. So, refusals to deal, right? Let's say we don't require firms to show a plaintiff to show that there was a prior course of dealing that the firm abandoned, which is one of the requirements under the federal case law, Trinco. The problem with that is, when you're proving that refusal to deal is anti-competitive, you don't just have to show anti-competitive harm. You need to say, why is this harmful to the competitive process? And when refusals to deal, profit sacrifice is one way to do that, right? So if you get rid of that requirement that says, firms, you don't have to prove that a firm has terminated a profitable course of dealing. You're basically opening the door to having antitrust law required to deal with firms, even if it's unprofitable, right? And that's not the sort of incentives that you want to send. Right. And, predatory pricing is another one, right? Under federal law, as Sasha mentioned, we have recoupment as a requirement, but also that a firm price below its costs, right? And showing that a firm price below its costs is a way to figure out, that they haven't acted on the merits, right? That they haven't acted consistent with the competitive process. They've excluded an equally efficient competitor in this case. And, if you get rid of that, you're going to be condemning conduct that's rational, right? A firm pricing above its costs or pricing at marginal costs. And if you get rid of recoupment, you're going to be condemning conduct that doesn't even harm consumers, right? So you always want to have this analysis. Does it harm consumers? Is it competition on the merits? And, if you allow courts to get away from the federal standards, you're going to risk chilling pro-competitive behavior that's not anti-competitive. Right. And, it's funny because in addition to these conduct specific rules, we also have these general tests sometimes. And one of them was in Section 3 was the no economic sense test. Right. And, this is another important test that courts sometimes rely on. Not as much for refusals to deal and predatory pricing, but things like innovation, right? Microsoft case, for example, you had technological tying, right? Is this innovation something that's done to exclude consumers, or does it have a pro-competitive justification, but for any competitive effect? That could be a very helpful analysis. But if you have a bill that's basically telling courts not to do that, right? Again, I think you're going to be pushing them in this situation where they're just going to weigh the harms and benefits of certain practices. Like, is this innovation good or bad, right? Without looking to see whether there's harm to the competitive process. I think that's going to pose a lot of issues. So again, it's good that they get rid of Section 3 if that's what they do, but the general problem in the bill about still wanting to move courts away from these standards, whether they're specified, expressly or not, I think has a real potential to do long run harm.
Thank you, Joe. Bilal, if I may come to you along the same point, but from an actual litigation posture, like what it might look like when the law plays out if it is passed. The language in the bill says, to repeat what Ben previously said as well, the language of the bill says that federal antitrust interpretations are at most instructive, and then says that a claim cannot be dismissed under Sherman Act case law unless the dismissal is also consistent with the new California chapter. In practice, let's say a defendant shows up with citing federal precedent law to show that the challenge conduct is actually lawful. How do you see this language playing out in the litigation posture, like at the pleading stage or maybe on the merits? How do you see this new law playing out in actual practice?
Look, I think a significant concern of the state law or the proposed state law is that it either conflicts directly with federal law or it allows the state court to adopt a different position than the federal law requires. And that's going to create some confusion in the operations of a business. At the litigation stage or in litigation, it will increase the likelihood that claims that are based on what I think Joe suggested, and which I agree, are both efficient conduct and pro-consumer conduct, that such conduct might be treated as a violation under state law. And so from a practical sense, that will extend litigation, right, from the summary judgment, motion to dismiss and summary judgment stage into a more merits-based trial, right? So it has costs and delay, and it may chill, people say chill pro-competitive conduct. At the operating sort of level of a company, they may be discouraged from engaging in activity that has long been thought to be pro-competitive because of a concern that state law will be interpreted differently than federal law. So I think that's the major concern, right? Differences between federal and state law, which will affect the operations of companies in California or operating in California. And it will affect consumers by at least at the margin, and discouraging efficient conduct, and it will lead to longer litigation and higher costs for firms, including small businesses who, we don't think of as monopolists or have monopoly power or market power, but who may have a significant following or share of the business they're in, and who also may depend on their relationships with larger firms in distributing the product. The uncertainty that the state law creates or may create will affect even small business operations because it affects their partners.
Thank you, Bilal. And thanks for mentioning the last point. Like to bring it back down to brass tacks about why this actually affects ACT members and why we take an active stance on this. For small businesses, they rely on the ecosystem that's built in for trust to reach the consumers, to scale quickly, to punch above their weight. They rely on the ecosystem built on practices that have been built on years of case law. And having vague standards and uncertain standards can put those practices in question, which then can in turn impact small businesses. Ben, if I may come to you a little bit, one of the amendments to the bill that were actually made in the assembly itself had an exemption for small businesses. What's your take on that? What are you hearing from businesses in California on their interpretation of this amendment? And does it actually address the small business concerns?
No. Long story short, absolutely not. So what the amendment claimed to do, again, was to exempt small businesses, quote unquote, small businesses of under 100 employees or 100 employees or less. That's not actually what it did. What it did do, I will say, I want to be sort of straight up about what it did do. It did say that employers of 100 employees or less um, are not subject then to investigations under the bill from a public entity like an AG or a DA. They are still subject to the private right of action. And I think, as we certainly all know, the likelihood of the attorney general coming in and investigating a 10-person, you know, restaurant in LA or somewhere is highly unlikely. The real liability here for small businesses is the private right of action, whether that's from competitors, unions, environmentalists, NIMBYs, whatever. And so it does not limit the real legal liability here from small businesses. And again, that's why I think you've seen there has been absolutely no removal of opposition from any of the numerous small business groups opposed to the bill, and there's been no outpouring of support. I mean, that's one of the points we're making. If the sponsors and author are saying this is supposed to benefit, small businesses, then why is there no big outpouring of small business support for this bill? And it's because of this massive legal liability that the bill creates. So it has not changed anything, certainly from our small business members or associations that represent small businesses at all.
Thank you, Ben. Satya, if I may come to you at this point, looking at in your paper that you recently published with the Innovators Network, the case for and against an American DMA, one of the themes was you assess practices. And again, like, we're not talking here completely theoretically. This experiment has been made here in Europe, where the laws have been put into place and the results have been assessed. Your paper talks about practices like self-preferencing, default arrangements, bundling, interoperability choices, app store restrictions, platform design decisions. How would AB 1776, like broad liability language, affect firms that use these practices to compete? And what impact could this have on the ecosystem overall, based on your research of what's happening in Europe?
Yeah, sure. So, there are a number of classic practices which could either be unreasonable restraints of trade or completely reasonable restraints of trade, depending on what their consequences and output are, right? So, for example, in the Microsoft case in the US, one of the principles they come up with is that, we're concerned with ecosystem competition. So rather than simply saying that within a digital platform, a firm highlighting its own, let's say, application in an app store or application in an operating system, rather than saying that, well, we're going to assume that this is going to be anti-competitive because they're trying to give themselves an advantage against other products, competing products on their ecosystem, like other web browsers, for example, other search engines. We're going to assume we're going to assume the negative, right? And then put the burden on the other side to maybe wiggle their way out of that and to say, well, actually, there's a pro-competitive reason we're doing this. And that creates a lot of uncertainty. And that's essentially what the Compete Act does. It upends things, precedents like Microsoft, which have made it clear that ecosystem competition is important, and curating an ecosystem is like creating your own product. So there's a reason why some people prefer Android phones to Apple phones and vice versa. It's a different user experience. The different standards for what apps are able to make it to one platform versus the other one. The other thing is, if I own a platform and I create a technology for that platform that, let's say, holds onto user data, I might want to initially only make that available to my own version of that product within my platform. Why? Because I control the security and the privacy features directly at arm's length. I have more control over that, and I can see how things play out and work from there. This then makes it highly questionable. Compete Act would make it highly questionable whether they can even do that, because technically what they're doing is advantaging one product, which is their own product, against the other competing products on their own digital platform. And you could say, well, that's designed to disadvantage the competitors and create an advantage for the guy who owns the platform. It could also just be to maintain security and privacy standards that benefit consumers. And what the Compete Act says is the defendant has now come out and say and prove through clear and convincing evidence that there was a pro-competitive justification for what they're doing that outweighs the anti-competitive impacts. And that creates a huge, massive amount of uncertainty. So what you're going to see is more and more firms, whether smaller firms, larger firms, hesitating or taking longer to come out with new products and new services because they don't know whether it's going to be illegal or not. And even if they can guess, okay, probably a court is going to side with us, that's still potentially years in litigation. That's still an incentive for lawfare. Private right of action was mentioned. And this really, is going to disproportionately burden really your smaller firms. I mean, we've seen what uncertainty can do in Europe, not just with the DMA, but with the GDPR, the privacy regulation. When that first came out, it wasn't entirely clear what a firm could or couldn't do. So it created this whole compliance industry where firms have to hire all these lawyers and other professionals to be able to try and do the guesswork to say, okay, what is a court or regulator likely to say? How are they likely to interpret this provision or that provision? And to highlight the uncertainty even further, the Compete Act keeps mentioning this idea that we are trying to go beyond the Sherman Act. So it's not enough to simply say, well, judges can still apply the Sherman Act. They're less likely to do that. If there's a judge who is not a fan of the precedents that would normally bind them, the Compete Act encourages them, incentivizes them to go beyond our understanding of what competition is. In its very preamble or statement of purpose, it says, competition isn't just about protecting the competitive process. It's also important to protect workers and our democratic and social institutions. These are vague and amorphous concepts that most businesses don't really try to think about when they're trying to make a product to serve the market. It's really the realm of other kind of areas of law and not competition law. So really, this really creates a massive amount of uncertainty, which manifests as a cost, and that cost is going to be passed on to the consumers through less innovation, less access to new products and services.
While I find the unmute button. Thank you, Satya. And certainly, research has already shown the cost of delays in Europe. Just to come back to you again, so do you see if measures like the Compete Act is passed in California, do you see similar delays that are currently happening in Europe where latest AI models are not being deployed? It's like latest in the news even. So currently, do you see similar delays for California-specific implementations of technology and if measures are passed like this?
Yeah, I think it's highly likely. And the irony here is, when a platform delays the rollout of a certain feature, that feature is denied to the small businesses that use that platform. So you're actually disadvantaging those small businesses by disadvantaging the platform they rely upon. And what we've seen in Europe with the DMA is that, Apple, Google, they have these new AI features, things like Apple Intelligence, screen mirroring, and so on. And they try to have conversations with regulators, and they try and to decide and to try to figure out, okay, is this going to fly, or is this going to violate the DMA or some other rule? And that creates more time, that creates more compliance costs. It simply might not be worth rolling out that service to the European market before other countries and small businesses in other countries get that service or get that product. So I think this is highly likely to repeat itself in California. And what's more, because California is such a big market, and because digital commerce by its nature is borderless, certainly within countries, if not internationally, the consequences are going to extend far beyond California. And it would certainly have implications for interstate commerce as well. And it's not clear, how those will end up being resolved. So really, the dangers, I think, from what we've seen in Europe, they could be quite severe if this goes ahead.
Joe, if I may come to you, jumping off of one of the points that Satya mentioned about what's in the preamble of the bill, the purpose of antitrust law and the goals of the bill. What is the difference between protecting competition versus protecting competitors? And what does that mean for the consumers and small businesses and people who are competing in the economic ecosystem?
Well, look, this is obviously one of the fundamental questions of antitrust law, and one that the courts have grappled with for well over a century. And I think there are two things to keep in mind when you're thinking about unilateral conduct, typically exclusionary conduct. So first, conduct that harms competitors is a necessary but not sufficient condition to show exclusionary harm through unilateral conduct, right? You also need to show that there's some maintenance or creation of monopoly power, right? And the best way to do that is to show direct price effects, or higher prices, reduced output, or diminished innovation, right? So again, take the example of predatory pricing, right? Low prices benefit consumers, even if they may exclude competitors, right? Which is why there needs to be some proof of recoupment, right? It's not just that there's harm to competitors, you have to show harm to consumers, that there's some monopoly power that's been created or maintained. So the next thing that we need to think about, and this is really important, is that just because you may have a monopoly that does something that in theory could harm consumers, doesn't mean you have an antitrust defense either. A lot of people don't understand this, but it's true, right? So take the example of a monopoly raising its prices. Right? That can harm consumers, a monopoly raising its prices, but it's per se legal under the antitrust laws, right? A company can blow up their factory, right? That can reduce output, but it's also lawful under the antitrust laws. Well, why is it? Because there's no harm to the competitive process. This isn't the sort of thing that we think isn't competition on the merits, right? And it's complicated in cases, but again, as I mentioned, if you have refusals to deal, right, you have to show that there's some harm to competition on the merits, right? That there's some profit sacrifice that's going on. That's why we have things like the prior course of dealing requirement. And then also predatory pricing, right? Same thing. Did they price below cost, right? Did they do something that offends the competitive process, right? You need to ask these questions if you really want to get at a true exclusionary offense, right? Harm to competitors isn't enough. There has to be harm to consumers, and there has to be some harm to the competitive process. So, where I think a lot of these unilateral conduct regimes, but also even in Europe, frankly, the way that they've been doing it over there in their antitrust laws is, they talk about fair competition. And what in practice that means is really just harm to competitors, and not really that much more will get you a violation, a single firm conduct violation, right? You don't really even need to show consumer harm. Maybe they're not going to do a robust analysis of competitive process, right? In many cases. And, that's where I think you really have to worry about a single firm conduct regime that chills pro-competitive behavior, right? Because it's not getting at whether this conduct actually harmed consumers, and really a true process violation, right? Really something that's not competition on the merits, right? So it's a tough line to draw, but I do think those are important guiding principles that we've got, over a century of case law. And this bill doesn't seem very well suited necessarily. It seems like it's very easy for it to go in the wrong direction. Let's put it that way.
Thank you, Joe. And for the audience and attendees, we're here coming to our last couple of questions. So if you have any questions, please use the functionality to add your questions, and we'll try to get to it at the end of the webinar for Q&A time. Bilal, if I may come to you on that, you previously mentioned small businesses in the context of this policymaking action. The playing devil's advocate to what we've been saying, and putting the policymakers, the people who are proposing this bill's hat, they argue that AB 1776 is necessary to protect small businesses and consumers from dominant firms. Where does that narrative fit in? Is it accurate? Does the bill achieve its purpose? Should policymakers do something else instead? What's the role of federal law in helping with the goals? Just your thought on that.
Well, it's a good question. I think it assumes that the scope of antitrust law is to protect firms rather than protect competition, right? So to the extent proponents of the bill suggests that legislation is needed to protect small firms against larger firms, or even allegedly dominant firms, the right question to ask is, what is the basis for the distinction between the larger firms and the smaller firms, right? If it is customer preference, efficiency, cost, then if you're protecting smaller firms at the, what I'd say expense of larger firms that are more efficient, who have, where customers have expressed the preference for those larger firms, then you are protecting competitors and not competition. And that is, there's a fairly long history of the antitrust laws doing that, but it led to, I think we believe inefficient conduct by firms and lower welfare for consumers. Now, if the concern is that larger firms are predating against or excluding smaller firms, that's what the federal antitrust laws reach. We've seen in the two cases against Google that the United States brought, that federal antitrust law can protect uh, competition, right? Um, and avoid protecting inefficient competitors. So I think that's the big issue, right? What is the meaning of that language of or belief that you need to protect small firms from allegedly dominant firms? That's not the role of antitrust law. There are other state laws that protect small firms from, what you might call inequitable or unfair conduct. There's business tort law. There's laws related to contracts. Um, so I think folks who propose this state law for that purpose are, in a sense, uh, overextending state law into areas where the federal law has a specific framework of protecting competition, protecting consumers, protecting and enhancing consumer welfare, not protecting smaller firms, uh, particularly those firms that are smaller because they're less efficient, um, and less preferred by customers.
Thank you, Bilal. And Satya, if I may come to you for one final question. We talked about federal precedent. We talked about the history of case law in interpreting antitrust laws here in the US. Uh, a big argument for proponents of modifying laws is the challenges that digital markets present. And I know in your research, you've written on a federal precedent and litigation here in the US that have adapted existing laws to digital markets, like in the Google search case and Epic, Apple, Microsoft, Amex cases. Um, what is the real risk that AB 1776 presents in pushing courts away from the body of precedent? And is the body of precedent adequate to deal with the novel challenges that digital markets pose to law?
Yeah, sure. So, I've already spoken about what the uncertainty, creates, how it creates a bigger doubt, more legal costs, more consulting costs, more costs in terms of risk aversion. So you retool your product to minimize the risk you'll be sued, um, because you don't know what the end outcome of that litigation would be, and you don't want to end up in litigation at all to begin with. Um, so, over time with these precedents, courts have come up with ways to judge competition in different contexts. And often, they'll find parallels between competition in a new context and a competitive market as it exists in the past. So, for example, the Microsoft case, which involved competition between operating systems and whether tying your operating system to your web browser is just a curation decision between two operating systems or whether it's unduly restricting competition within the operating system. That principle was applied in the Google search case to say, okay, uh, when you have a web browser, you're creating really a user experience. So when a web browser decides we'll take money from a search engine to make it the default search engine on the web browser, that does come with benefits. It makes it easier for consumers to access, an ostensibly reliable search engine quickly. It brings in funding that the web browser can then use for its own development, which means it doesn't have to, turn to advertising as a source of revenue, which would harm the user experience. And so, I think a good example of this kind of like pragmatic exercise, actually, looks at how we even define markets to begin with. So the Amex case, for example, involved what we call two-sided markets. So credit cards bring together customers on one side and merchants on the other side. But if you really think about it, what are they selling? They're not really selling two separate products. They're selling one product, which is the transaction itself. They bring together two sides. And any two-sided platform like that is going to have to make decisions that either advantage or disadvantage one side of the market at the expense of the other. So, an operating system or on an iOS, on a phone or on a computer, might impose certain requirements on the small businesses that operate on a system that are designed to increase and enhance the user experience while imposing costs on those small businesses. But if you come out saying, no, we are concerned with competition, but we define the market as the customers being these small businesses and the service being access to the platform, then you can say, well, no, I am preserving the competitive process. I am I'm ruling against the platform putting these requirements on the business on its platform. In doing that, you harm the other side of the market, you harm the consumers. But you've said, well, we've defined the market this way, so this bears out in practice. So by upending the precedent, you've now invited the opportunity to go back to that old world, which completely ignores the dynamics of digital markets. So it's not about making the law more adaptable to digital markets. It actually makes law less adaptable, but getting rid of the precedents that would allow us to understand these dynamics better.
That's very interesting. Thank you. And it's really the wisdom of history, decades of case law that's adapted to new markets that this bill risks not being in place in California. So we reached pretty much at the end of our time. Thank you all so much for joining us. Thank you for the attendees who joined as well. This webinar will be recorded and posted after the fact as well. So thank you again, and we'll keep an eye out for AB 1776 and where it goes forward. And really appreciate it. Thank you all so much.
Thank you.
Thank you.
Thank you.